To put today's webinar in some context, I want to read a quote. It says, many consumer financial products like credit cards and bank accounts have contract gotchas that generally prevent consumers from joining together to sue their banks or financial company for wrongdoing. With this contract gotcha, companies can sidestep the legal system, avoid accountability, and continue to pursue profitable practices that may violate the law and harm countless consumers. Those are not the words of a plaintiff's counsel or of a consumer advocacy group, but rather those are the words of the CFPB itself in announcing the study that we're going to be talking about today. The lyrics of a song made popular by Prince say, "I know the times are changing. It's time we reach out for something new." I'm not sure that what we're seeing here is in fact the reflection of changing times, but rather a change in the way the regulators view those times. My name is Lou Wiener. I'm a partner at Sutherland, Asbill & Brennan. I'd like to welcome to our webcast, Arbitration Agreements and Class Action Waivers, a discussion of the potential impact of the CFPB's proposal regarding arbitration provisions, class action waivers. I'm joined today by my partner, Tom Byrne, and our colleague, Frank Nolan. Tom is a leader in Sutherland's consumer finance litigation practice with extensive experience enforcing arbitration provisions in the context of consumer finance contracts involving class action waivers. While the Supreme Court has been dealing with this issue for the last 6 or 7 years, Tom's experience, more particularly in state court and then leading to federal court, extends back over 2 decades. Tom is a thought leader both in our firm and in the legal community at large on the issue of consumer finance litigation and specifically as it relates to arbitration provisions and class action waivers. Frank Nolan, our colleague, is an associate in the firm's New York office who has spent 8 years working on class action issues as they relate to consumer finance issues. Frank has developed a specialty in the areas of arbitration clauses and class action waivers. I head Sutherland's insurance and financial services litigation practice and have spent the better part of the last decade litigating issues relating to arbitration agreements and class action waivers. With that as introduction, as you all are aware, last week the Consumer Financial Protection Bureau proposed a rule to ban enforcement of class action waivers included in arbitration agreements found in many consumer-related, finance-related agreements. During today's webcast, we'll discuss several aspects of the CFPB's proposal, including some of the mechanical issues, scope, timing, required language, submission of documents, and enforcement of the rule. We'll also talk about implications of the rule and ultimately steps that can be taken to let the CFPB know where its analysis has fallen short and misses the mark. There are a few housekeeping items we'd like to cover before we get started today. If you'd like to receive CLE credit for this webinar, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. If you have any questions during the webcast, please submit them via the Ask a Question text box on your viewing console. If you'd like to request a copy of the slides, please contact me, Frank, or Tom, and our contact information will be on the last slide today. For those who would like to receive CLE credit for today's webinar, I will be announcing a confirmation code in the middle of the presentation. Please make sure you write that down. You'll need it in order to get the CLE credit. With that, let's turn to the CFPB's proposed regulation. The CFPB's proposed regulation has 2 parts. The first is a prohibition on class action waivers. Creditors may not use an arbitration provision to stop you from being part of a class action case in court. That's the required language that's proposed by the CFPB. You can still have arbitration provisions in contracts. They cannot include class action waivers. That doesn't mean that you cannot have a standalone or naked class action waiver in a contract. It just means it cannot be part and parcel of an arbitration provision. The second prong of the CFPB's proposal requires the submission of documentation and information to the CFPB, in that you must file with the CFPB copies of an arbitration agreement, a claim, any counterclaims, the award, and certain communications with the arbitration administrator. The CFPB proposes to then bundle or aggregate that information and will publish it in some form at a later date, none of which has been specifically identified in the proposal. The question then is, so we know what it does, who is affected. The proposed rules will apply broadly to most consumer financial products and services, including, in the language of the CFPB, those related to the core consumer financial markets that involve lending money, storing money, and moving or exchanging money, end quote. In practical terms, the proposed rules will affect virtually all consumer financial service companies, including banks of all sizes, creditors, servicers, sellers and purchasers of consumer debt, providers of credit reports, debt management and debt settlement companies, debt collectors, person holding deposit accounts, offering remittances and other payments, check cashers, check guarantee companies, payday lenders, and there are certain limited exceptions to that. The exclusions pursuant to proposed section 1040.3 subsection B would exclude the sale of non-financial goods and services, broker-dealers subject to the SEC rules, governments and their affiliates, providers of covered products or services that are offered fewer than 25 times per year, and providers not subject to DoddFrank, so for example, hospitals and auto dealers. Tom, you'd like to pick us up on the application?
Sure, Lou. Let's look at with a little more depth at the implications of this rule and how it would operate in the future if it becomes final. We won't be putting this on our website, but the bottom line here is that basically this rule, if it becomes final, would outlaw using arbitration as a tool to defeat class certification. The language is very broad. It states that the provider, which is basically, in this context, the creditor, shall not seek to rely in any way on a pre-dispute arbitration agreement entered into after the effective date with respect to any aspect of a class action related to consumer financial products or services. That bar continues until the court has ruled that the case may not proceed as a class action, and any interlocutory appeal that is available has either not been sought or the review has been resolved, is the word that is in the proposed regulation. So this would apply to state and federal class actions. There's no federal claim required. So if for example, a state court class action that asserts fraud or an unfair and deceptive trade practices act violation, the rule would apply to that kind of case as well. You can see right away that it seems to create a perverse incentive to label any individual case as a class action in order to deter or delay arbitration that the plaintiff may seek to avoid. Now, a class action waiver in a arbitration agreement can still be enforced after the effective date if it is in a pre-effective date agreement, though I'm afraid the courts are likely to be emboldened to accept the hodgepodge of anti-enforcement arguments that are out there right now, making their way through the state court systems. Now, so the challenge will be after the effective date, you will see cases initially that have a mix of contracts, and the key there will be to move to compel arbitration early with respect to any putative class members who are governed by pre-effective date agreements. The experience should be similar to something we've seen before in some aspects of our industry, and that is where you have a class with some people who have arbitration agreements and some consumers who do not. And quite often, when the class representatives don't have arbitration in their contracts, the court tends to resist the full implications of the fact that most of the proposed class has arbitration agreements. So that experience may be valuable and helpful in dealing with the brave new world that will happen, will be upon us after the effective date. Now, 1040, the proposed rule 1040.4A2 is the required language provision which makes you insert in your arbitration agreement, if it's a post-effective date agreement, a statement that we agree that no one else, that we nor anyone else will use this agreement to stop you from being part of a class action case in court. You may file a class action in court, or you may be a member of a class action even if you don't file it. And that language would need to be in every contract entered into after the effective date. There's also a modified provision of the rule that deals with multiple products and services where some are subject to the rule and some are not. Now, what do we see here? Well, first, the rule oddly doesn't seem to say that contradictory class action waiver language must be deleted after the effective date, but that's clearly the implication. And a question is presented really about anti-class arbitration language, which almost everyone has had in their arbitration agreements for most of the past decade after the disastrous Basel decision created a cottage industry of class arbitrations for an unfortunate period. Anti-class arbitration language would appear to be permissible. I think there may be a question or two about how it's enforced. And so one wonders whether class arbitrations will return. The major arbitration sponsors are more skeptical of them now than they were when they originally rolled out their class arbitration procedures. And clearly the providers or the creditors won't be able to initiate any arbitration until class cert is denied. So no reason perhaps to go to arbitration at that point in time when you've already won the class cert fight. The consumers, of course, can initiate arbitration, but almost all would probably prefer to be in court. That's what their lawyers' preferences will be now that they're allowed to do so. So it remains to be seen whether we'll have a reprise of the class arbitration wave that we saw in the middle part of the last decade, which was really the worst of all worlds because of the limited appeal that was available and other steps that were being taken across the country to restrict class actions. Now, the other aspect of this that Lou mentioned is what the CFPB calls the monitoring provision, which is 1040.4B, and it imposes rather onerous monitoring requirements which frankly seem intended really to dissuade individual arbitrations altogether. The ostensible purpose of the monitoring provision is to gather data with respect to individual arbitrations and their impact on consumers for the purpose of considering perhaps further rulemaking. But the requirements would require quite a bit of documentation and a short window within which to provide it of 60 days after receiving or filing a covered document, which includes the initial claim in arbitration, any counterclaim, the award, any judgment, and certain communications with the arbitration administrator that are specified in the rule. So pursuing an individual arbitration after the effective date will be even more onerous than it is now. And as we know now, the entire expense of the individual arbitration, almost entirely, is borne by the creditor. Lou, should I say a few words about timing at this point?
Yeah, Tom, let's talk about the timing, because there are timing. This is not immediately effective, but rather follows a prescribed notice comment period. Would you talk a bit about that?
Well, the rule specifies the standard 90-day comment period, which runs from the date of publication of this rule in the Federal Register. So that hasn't been published yet, so presumably that'll be sometime in August. Now, after that comment period, how long before the final rule is issued is uncertain. There are no timing requirements. It would be up to the Bureau if they wanted to. They could withdraw the rule, of course, but that isn't likely to happen. But so there is no strict timetable that governs that step in the process. Now, once the rule becomes final, it should be subject to the Congressional Review Act, which is a statute passed in the mid-'90s intended to provide for expedited review of government regulations by Congress, and it does streamline Congress's internal procedures for bringing a resolution before both houses. The one requirement is that the issuing agency, here the Bureau, submit the final rule to Congress and to the GAO, the Government Accountability Office, for review immediately upon adoption. If the rule is deemed a major rule, and that decision is left in the Office of Information and Regulatory Affairs, then there are some additional requirements. The effectiveness of a major rule is delayed for at least 60 days after being submitted to Congress and could be delayed somewhat longer depending on what Congress does. A major rule is defined as any rule that the Office of Information and Regulatory Affairs finds likely to result in an annual effect on the economy of $100 million or more, or a major increase in costs or prices for consumers or individual industries. So it's hard to see how this rule could not be deemed a major rule, even looking at the face of the Bureau's materials submitted with the proposed rule. So once a resolution of disapproval from both houses is enacted, if it is, and that would be difficult here in this climate, the resolution is still subject to a presidential veto, which seems quite likely if it comes before President Obama. And you have to be skeptical about the history of these resolutions. There have been 99 or so of them passed and have been introduced to Congress since the adoption of the Act, and only one agency rule has ever been invalidated. So this is a step in the process likely, but it doesn't seem likely in the current configuration to be an impediment to this rule taking effect. Interestingly, there's already been a request for documentation by one of the House committees, and it focuses largely on contacts that the Bureau had with representatives of the trial lawyer community. So the political process here will heat up shortly. Now, the effective date of let's assume that there is no congressional resolution, the effective date is 211 days after publication of the final rule in the Federal Register. That takes into account the required DoddFrank 6-month delay that is in Section 1028 of the statute, and then an additional standard 30 days for the rule to become effective plus a day. So that probably, just guessing, that probably puts the effective date of this, if all goes as the Bureau seems to plan, sometime in the spring of 2017. There will be abundant headaches in the transition. I think everybody recognizes that. That will affect some industries more than others, particularly with the implementation of or the removal of old contracts, the implementation of new contracts with new forms. To get full advantage of arbitration, I guess the goal would be to use the old contracts right down to the effective date, but that may be logistically impossible, especially in decentralized industries like auto finance, because there's a lot of reliance on different forms and some on generic forms. So that may be a goal that can't be realized.
I'm sorry, Tom. There was a question that's been asked that I just want to pick up on. It says auto dealers are excluded. If so, do you think that indirect auto lenders who purchase retail installment sales contracts from auto dealers will be able to enforce arbitrations in such agreements? There's an interesting part of the the study, or the proposal, the CFPB proposes to have the rule apply to contracts that, quote, existed previously between other parties. The meaning of that language is a little unclear. The example provided by the CFPB is one bank purchasing another bank whose consumer contracts included arbitration clauses that predated the rule, in which case the CFPB proposes to require the acquiring bank to modify those contracts to comply with the new rule. Although unclear from the example, the commentary associated with that suggests the CFPB would apply the rule to acquisition of a portfolio of contracts even where there's not a change in the servicer. So I take that to say that they may require, if you do acquire, in the context the question was asked, these contracts, that they be brought into compliance with the rule. But I just wanted to address that in the context of this discussion. Tom, I'm sorry, let me throw it back to you.
On the question, I don't think that indirect auto lenders will be able to take advantage of the dealer's arbitration agreement, which is often found in a buyer's order. I think the dealers should be able, and the Bureau is dancing around this, and I expect they'll get heavy comments from the NADA, but the dealer should be able to enforce its arbitration agreement against the customer. But when it comes to the acquirer of the contract, they won't be able to enforce it. I'm certain that'll be the Bureau's position, and that's likely to be how the rule is interpreted, if the rule becomes final. I was going to say a couple of things, Lou, about the future of arbitration. The question may become whether or not there's any purpose in continuing with arbitration agreements given the expense of the process with respect to individual claims. And I expect that the answer there may vary with creditors. Now, creditor-initiated arbitrations are subject to moratoriums by the AAA and by JAMS, and so the NAF is out of the business entirely. So creditor-initiated arbitrations don't have any usefulness to creditors. There's no longer apparently going to be much value in resisting class actions from having an arbitration agreement. And all of them have a small claims court exception already, which is consistent with the AAA's due process protocol and other fairness standards that are now adopted by the administrators. So the question may come down to whether the particular creditor faces defensive litigation that is of a nature that would be best met with the availability, at least, of individual arbitration. The advantage of arbitration, again, you got to pay for it because the consumer typically pays the filing fee, and that's it. And although some agreements do feature caps on overall administrative expense. And the other problem is the limited appeal that's available from arbitration if something goes bad, which has been a concern, of course, for many years in the use of these agreements. If you recall, the origin of the use of consumer arbitration agreements really was initially to stop runaway jury verdicts in places like Alabama and Mississippi, where these first came into more widespread use. But then the Supreme Court came to the rescue with BMW against Gore and began imposing due process limits on punitive damages, so that problem faded, and the advantages of defeating class actions through the use of arbitration agreements moved to the fore.
Great. Frank, in the words of the Grateful Dead, what a long, strange trip it's been. How did we get here?
So Tom was talking about where we're going. This study, the proposed regulation rather, came out 6 days ago, and it could go into effect as early as a year from now. But this has been coming down the tracks for a long time. So the DoddFrank Act requires the CFPB to study these provisions and gives them the power to effectuate that study in a regulation. So subsection A gives them the power to study. Subsection B gives them the power to regulate arbitration agreements, provided that the findings in each rule shall be consistent with the study conducted. And we've reviewed the regulation, we've reviewed the study, and there's no doubt that the proposed regulation follows the study. Whether or not the study is flawed and therefore the regulation is flawed is another matter. So the study that the proposed regulation was based on was released in March of 2015. And that first quote that we have on the slide, you'll see, the study showed that at least 160 million class members were eligible for relief over the 5-year period studied. Those settlements totaled $2.7 billion in cash, in-kind relief, and attorney's fees and expenses. So that's a very loaded quote for a couple of reasons that we'll get into later. But I just highlight that a few parts of it. The 160 million class members eligible for relief, the settlements for those proposed class actions, and the attorney's fees. So it's not saying that 160 million people collected after a jury verdict in a class action trial. And it's not even saying that 160 million people collected when they were eligible to as part of a proposed settlement class. It's also saying that $2.7 billion, part of that was in attorney's fees. And Lou's going to talk about that a little bit later. But that's a very loaded quote. So the study found, one of the many numbers that the study noted was that more than 75% of responding credit card consumers did not know if their credit card agreement included an arbitration clause. Now, we'll talk about that. That's basically a way of saying that it was buried in the fine print. So we'll talk about that later as well. Another number that the study relied on was that arbitrators required consumers to pay $2.8 million because the fact is that these arbitration provisions work both ways. That was something that was really not focused on in the regulation or the comments by the CFPB when they released the proposed regulation last week. But the conclusions of the study are that the increasing prevalence of class action and class arbitration waivers are harming consumers who would be better aided by traditional litigation, including and especially class action lawsuits. So it concluded specifically that class action litigation is superior to individual arbitration. So implicit in that is the assumption that class actions are superior to individual litigation. Also implicit in that is that the defendants in these class actions, whether or not they went forward to a verdict or they were settled or even just settled on an individual basis, is that the defendants acted unlawfully, even when. So that's something just to keep in mind as we move forward with the presentation.
One of the interesting aspects of the report is the absence of any real discussion of the Supreme Court cases that we're all familiar with: Stolt-Nielsen, Concepcion, American Express, DirecTV, etc. Over the last 6-7 years, the Supreme Court has consistently ruled in favor of the enforcement of arbitration provisions and class action waivers. The CFPB is arguably not looking to change the law as it was announced by the Supreme Court, but rather impose a different set of obligations on consumer finance companies and related companies as it relates to arbitration provisions. Nevertheless, to read the report, you would think that the Supreme Court had never weighed into the area. I think Stolt-Nielsen is mentioned in one paragraph, and the American Express v. Italian Tricolors case has been relegated to one sentence in one footnote. Again, as if these cases were never considered by the Supreme Court, and as if the underlying premise of these cases, the issues of public policy, enforceability of class action waiver, etc., were never considered. So you end up in a situation where we have what looks now to be somewhat of a Pyrrhic victory in the Supreme Court pronouncements over the years of enforceability of arbitration provisions and class action waivers, and yet what the Supreme Court giveth, the CFPB taketh away. Again, I think it ultimately will result in a challenge to the CFPB's rulemaking, and it is contrary to the law as announced by the Supreme Court. But again, we're to a certain extent arguing apples and oranges there. A question's been posed as it relates to what the CFPB has done here, and the question is, can we address the potential for other agencies to pass similar rules? I don't think that there is much risk of other agencies passing rules like what the CFPB has done here, simply because of where this rule comes from. It comes from a delegation of authority, and specifically in the Consumer Finance Protection Act, the CFPB was authorized by Congress to study the issue, to issue a report, and then the recommendations become self-effectuating. Other agencies don't have that same authority. That's not to say that Congress can't do anything, but I don't think the agencies themselves, absent a delegation of authority and having the specific authority as does the CFPB, could do this. There is a certain amount of speculation in that, but I think that we have to look at and consider how the CFPB arrived at this point, and what its authority is based on as the foundation for the rule. Tom, Frank, any thoughts on that?
I agree, Lou, and of course HUD probably not terribly interested in it, because most mortgages are prohibited from having arbitration agreements by another provision of Dodd-Frank. So I think that you would expect other federal agencies here just to defer to the CFPB, which has the statutory authority to act, and boy, has it acted.
Tom, I'm going to throw the next question over to you, because I know it's an issue that we discussed in preparation for the presentation, but the question is, can we address the basic separation of powers preemption issue? How can an administrative agency operating with a general mandate overrule legislation upheld by the Supreme Court? Let me throw that over to you, Tom.
Well, it's a very good question. The agency is not really overruling the Supreme Court, however. What the Supreme Court was doing was applying the FAA, and the Bureau's position is that it has been authorized by Congress in Dodd-Frank Section 1028 to issue regulations that prohibit use of an arbitration agreement or impose conditions on it. The presentation materials by the CFPB crow a good bit about the fact that they could have entirely outlawed arbitration, but all they did was prohibit it from being used to deter class actions. Well, they know full well that's really where the money is here. But that may be the difference with respect to the Supreme Court line of cases. Now, the separation of powers arguments have been raised recently in the PHH appeal of the $100 million disgorgement penalty imposed by Cordray in an enforcement proceeding before the Bureau. And in the recent argument last month, I believe it was on April the 12th, and there's a slide we have in front of us now with a few details, the creditor, the PHH, argues that the CFPB violates the constitutional provision on separation of powers in several ways. I mean, first, Cordray is not answerable to the President, and he's removable only for cause, which the PHH argues is a violation of the faithful execution clause of the Constitution. In addition, of course, the director of the CFPB sets his own budget, and it's prohibited from any review by Congress. He gets his money right out of the Federal Reserve. again, that unchecked use of budgetary authority, especially by an agency that doesn't have a multi-member commission structure, is challenged. So this argument, however, is at the very end of the arguments made by PHH, naturally, and so they do preserve it, but there will be it may be tough to establish. They concede, for example, that some elements of the agency structure, perhaps the sole member feature, probably could be individually permitted under case law, but emphasize that when you blend them all together, it makes a good case for separation of powers. So we should know relatively soon, I guess, though it is the D.C. Circuit, so maybe not that soon, how this comes out.
Again, just looking at PHH, the issue there was the CFPB itself had argued for the $100+ million penalty, which was rejected by the administrative law judge, who awarded a $6 million disgorgement penalty. It then went back to Director Cordray for a review, and what did he do? He imposed the fine that they recommended initially that the administrative law judge rejected. So you do have a situation where the CFPB is literally and figuratively acting as the judge, jury, and executioner, as well as the appellate board, which again gives rise to the claims and the challenges that Tom mentioned. We do have another question about the likelihood of a successful challenge, and let's turn to that and issues on challenging the proposal. There is a comment period. One of the things that I thought was striking about the proposal itself is that they talk about the comments that the CFPB received in response to the initial study, the initial report. And you would think that given the number of entities affected and the money involved, there would have been a lot more comments. And I was surprised by how few comments the CFPB reported receiving on its report. So I think that one thing to take away is that the comments are important. They do get read. And I think that it would be folly to assume someone else is going to cover that. So I think taking advantage of the comment period is important. And then what is the source and what should be the focus of those comments? Well, I think that the comments have to point out the flaws in the study, the flaws in the analysis. Let me give you an example. The analysis in the report doesn't say anything about attorney's fees for plaintiffs' class action lawyers. In my opinion, that's what's driving a lot of the class action, plaintiffs' class action filings. The CFPB kind of cloaks itself in this flag of we're protecting the consumers, but do the math. The CFPB's own numbers say that for settlements of class actions, that yielded for the time in question, which I believe was a 2-year period, yielded $2.7 billion. 5-year period, yield $2.7 billion in favor of consumers. Of that amount, approximately $500 million was attributable to plaintiffs' counsel's attorney's fees. I think that's an understated number just using the percentages that the CFPB itself has reported in the report. Nevertheless, just using their numbers, that resulted in $2.2 billion being available for distribution to 160 million plaintiffs. That's eligible for distribution, not necessarily claimed. Do the math. That's under $14 per plaintiff. And yet, if you look at the amount that the plaintiff's counsel are getting, it pales, and the amount that the consumers get pale in comparison. That's what's driving these lawsuits. We defend dozens of class actions every year. We see class actions where the plaintiff's counsel is getting 7 digits. The consumers affected that are the subject of the complaint that the CFPB and others are looking to protect get on average $8. Most people don't claim because, frankly, it's not worth their time to claim. So what's driving this? Is it, as the CFPB has asserted, they're looking to vindicate the rights of the individuals, to hold corporations accountable? I think that's a lot of rhetoric and doesn't get to the real issue, and that is what's driving this is the plaintiff's attorneys who are lining their pockets and arguably are taking advantage of the consumers just as much, if not more, than they are accusing the people in the consumer finance areas of taking advantage of the consumers. Either way, the consumer is from my perspective, coming out second here. And I think that that's something that I think it was intentional, that it was not addressed by the CFPB, but I think it's glaring that they have failed to address it. Similarly, they address what I consider to be the tort reform issue. They talk about it in terms of a COA, the Equal Credit Opportunity Act, and they note that the original limit on damages for COA violations was $100,000. The ceiling was then raised to $500,000 and ultimately to $1 million. For those familiar with California law, there's the Rosenthal Act, which is the California version of the Fair Debt Collection Practices Act, which has in it a damages limit. I think if the CFPB were in fact exercising fidelity to the idea that they are looking to correct alleged illegal or again, we'll just call it the language that the CFPB uses, which is illegal conduct, I think that they could achieve that result while striking some type of balance, namely have a limit on damages which would focus on changing the behavior, but more importantly would limit the availability of attorney's fees to the plaintiff's counsel. And I think that would present a more balanced proposal, but yet was completely devoid of any discussion or any meaningful discussion in the report.
Lou, let me offer a couple of thoughts about Mike Perret's question about the likelihood here of getting any relief, either in Congress or through litigation. I may be more pessimistic than most folks, but it's really hard to be optimistic about it given the current climate and the rules that apply. I mean, first, there's going to be a difficult arbitrary and capricious standard would have to be met in challenging any final rule. That can be done, has been done in other industries with elaborate administrative records, especially where there's science involved. Not so much of that here. There could be an argument made that the study itself is not bona fide and doesn't meet the requirements of the statute that there be a prior study. There's no doubt here, I don't think there will be an argument that the proposed rule is faithful to their study. It follows it very carefully, naturally. But whether or not the study is bona fide seems like a fair question, but again, another difficult one. And then there is the set of arguments made in the PHH case about separation of powers, plus potentially a delegation doctrine argument about Section 1028, because it does delegate authority rather broadly to the Bureau to decide what to do about consumer arbitration. Now, there hasn't been a delegation doctrine success in the courts since 1935, and the standard is whether or not there's been an intelligible principle by which Congress directed the agency to make rules. So again, another difficult argument, but one that probably will be dusted off and looked at more carefully in light of this rule. Another reason it's kind of hard to be real optimistic is we have an open seat on the Supreme Court, and Justice Scalia was, after an initial halting start, very friendly toward arbitration. Now it looks like it would be 4-4 on any close question about this, and Justice Thomas's vote is not reliable because he is often opined that that the application of the FAA in state courts is unconstitutional. So, and with that situation and the fact that many of the federal circuits, as their membership has changed over time, are now trending more liberal than they had been for many years, it's really hard to see any judicial outcome here and say that it seems likely that the rule would not pass muster. The real wild card, perhaps, is the election. So if there's a Republican president, then it's an entirely different world, but of course, that's anybody's guess.
Thanks, Tom. For those who have been waiting for the code for the CLE credit, if you do want to receive CLE credit for today's webinar, the confirmation code is arbitration. Please use this code for the sign-in sheet available for downloading from your viewing console. Frank, let's get back to the issue of the concerns regarding the CFPB study.
Sure. Once the comment period begins, that's a real opportunity to point out to the CFPB what they probably already know is the number of flaws, and there's certainly no shortage, arguably. For one, they do not address the likelihood of an increased cost of products because of increased litigation costs, nor do they address reforming standard contracts to comply with regulations or even outright removal from contracts and the cost of that would be passed on to consumers. Now, it's actually not correct to say they don't address it, but they gloss over it and say that they welcome comment on it, although they do not think that that is likely to change their analysis. Another flaw, they accept all the alleged virtues of class actions, and they assume that defendants who settled did so because they were acting unlawfully, which ignores the enormous pressure that defendants are under to settle, particularly post-certification, but even before then. And they ignored the basic risk management principles that defendants face when they are hit with a putative class action lawsuit, and that maybe sometimes it's more effective to settle even if the suit is without merit than to go through the costly, expensive litigation. So they don't address that. They do not address or even pay any heed to any potential advantages of arbitration, whether or not you believe it's more quick and more efficient. It usually does not involve attorneys, which is certainly an advantage for defendants. Another big thing that they ignore is the distinction between types of arbitration provisions. And there's a specific example that we can talk about here. Under California's Discover Bank rule, which has since been overturned, it found that class waivers were unfair if two things were met. A single consumer has no incentive to arbitrate, and number two, if a consumer needed services of an attorney, which a small claim would not incentivize. Fair enough. AT&T's arbitration agreement was challenged in AT&T v. Concepcion, and it was ultimately upheld. But after that case was resolved, AT&T went back and they adjusted and revised their arbitration, their waiver agreement in their contract. First, they made arbitration free to customers, and second, they provided that any consumer who received even $1 more than their settlement offer in an arbitral award was automatically awarded a flat fee of $10,000 in addition to the arbitral award. And on top of that, the attorneys for the consumer, if they did bring one, would get twice their fees and expenses, again, if the offer turned out to be less than the ultimate award. So they incentivized the use of arbitration on a single consumer basis. So the study and the proposed regulation ignored the differences between these potential waivers and provisions and lumped them all in together. Lou, I believe there's another question.
Yeah, no, it's fine. It's a procedural issue.
And Lou also mentioned comparing apples to oranges. And we talked about the class settlements and the numbers the mind-blowing numbers that the CFPB relied on in its study, $2.7 billion in settlement. they didn't compare that to arbitral settlements. They compared that to arbitral awards. They did note in a separate section that 59% of arbitrations on an individual basis are resolved before going to arbitration. So they're settled. If they did not compare those numbers to the potential settlements, nor did they compare arbitral awards to class action verdict awards.
One of the takeaways, there are two from my perspective. The comment period on the proposed rule provides an opportunity to raise important questions about the rule, including whether it's consistent with the FAA, the U.S. Supreme Court precedent, whether the CFPB has an adequate evidentiary basis for its conclusions, and has conducted a proper cost-benefit analysis to support the rule, and whether the CFPB improperly prejudiced the outcome of its arbitration study for the rulemaking process itself. Those who are affected by the CFPB's proposed rule should seriously consider submitting information relevant to the cost-benefit analysis of the proposed rule specific to your own business, including information about the cost of defending class action lawsuits, the average amount of award or settlement with individuals who have participated in mediation or arbitration compared to any benefit provided under class action settlements. While the CFPB, I think as Tom said, may make some minor revisions to the rule based on the comments it receives, we just don't expect the CFPB to adopt any major changes. But by submitting comments raising these and other concerns, those affected by the rule can build a record for possible judicial challenge to the final rule once it's published. The second takeaway is during the comment period, companies should also review their consumer contract forms to determine what modifications, if any, will be necessary and beneficial to their business interests if and when the rule becomes final. So again, sitting on your hands is not the recommended course of action here. There is a call to arms, if you will, to comment on this, to let the CFPB know how it's going to affect your business, and specifically to let them know what they have overlooked. But it's also an opportunity to take a necessary look at the contracts that you have. As I said at the very beginning of the presentation, the rule would ban class action waivers and arbitration provisions. That doesn't mean that a naked or standalone class action waiver might not survive. Query, when stripped from the public policy issues that support the FAA, whether a naked standalone class action waiver would apply, I think it's largely going to come down to an issue of state law. And some states are more supportive of those than others, but that's something that you should be considering, again, as well as a review of your existing contracts. Tom, in the last minute or so, closing word?
Well, it'll be interesting, Lou, to see. I think there will be various litigation challenges to this that are brought, and I assume they'll be brought through the associations in order to spread the cost of it, for one thing. So it'll be interesting to see how that develops over the next few months.
I understand there may be some issues with the CLE form. You have on the screen our contact information. If anyone is having any issues with the CLE form, please contact any of us, and we will make sure that we get that to you. I would like to thank everyone for joining us today. Again, the CLE form is the vehicle for getting CLE credit. If you have any questions, you do want to follow up, you'd like copies of the slides, please feel free to contact me, Lou Wiener, Tom Byrne, Frank Nolan. And we thank you very much for your time. Hope everyone has a great day.